The rain had been coming down since before sunrise, the kind that turns sidewalks into mirrors and makes everything smell like wet concrete and cold metal. By the time I reached the courthouse steps, my coat was heavy enough to pull at my shoulders. My hair was damp at the ends. My folder was tucked under my arm like a shield, but even it had taken on water. Dark spots spreading across the cardboard. Inside, the air was warm and dry and smelled faintly of coffee and old paper. A bailiff checked names at the door, and I heard my sister's laugh before I even saw her. She was already seated at the petitioner's table, perfectly styled, ankles crossed like she was waiting for a brunch reservation. Her lawyer sat beside her with a laptop open and a yellow legal pad lined up square with the table edge. Or my mother leaned back behind them with her arms folded. My father's expression was the same one he wore when he thought I'd finally run out of options. My sister's eyes landed on me and she smirked, quick and private, then leaned toward her lawyer like I was the punchline. Dad let out a low chuckle, the kind meant to be heard but not quoted. Mom didn't even look at me. She huffed and stared past my shoulder like I'd tracked mud onto her life. I didn't stop to argue. I didn't announce myself. I just walked to the respondent's table and set my damp folder down carefully, right in the center, letting the water-darkened edges show. The clerk called the case and we stood. The judge entered from the side door, robe swinging slightly as he took his seat. He was older than I remembered, but not softer. His eyes were sharp in that way that doesn't come from anger, just from years of listening to people lie under oath. He glanced at my sister's table first, then at mine, and then he paused. It wasn't dramatic. It was the kind of pause that happens when a thought interrupts routine. His gaze locked on my face like he was matching it to a memory he didn't expect to find in this room. His mouth parted slightly, then closed. He looked down at the case caption, then back at me. His eyes went wide, just for a beat, and he leaned closer to the mic like he didn't realize the whole room could hear him. "I can't believe it's her," he murmured. Silence swallowed the courtroom so cleanly you could hear someone in the back shift their chair. My sister's smirk faltered. Her lawyer's pen stopped moving. My father's chuckle died in his throat. And the judge cleared it away quickly, as if he'd shown too much on his face, then forced his voice back into neutral. "Counsel," he said, "this is an inheritance dispute?" My sister's attorney stood smoothly. "Yes, Your Honor, it's simple. The decedent's granddaughter manipulated an elderly woman. My client is asking the court to award the estate assets accordingly today." He said it like he was reading a grocery list. My sister leaned toward me and whispered, low and sharp, "Sign it and stop embarrassing yourself." I didn't look at her. I looked at the judge. When the lawyer finished, the judge's eyes flicked to me again. "Ms. Pierce," he said, "do you have counsel today?" "I do," I said, and gestured toward the attorney beside me. She stood briefly, introduced herself, and sat. The judge nodded. "All right. Ms. Pierce, I'll hear from you." My attorney began, calm and plain-spoken. She didn't grandstand. She didn't insult anyone. She just said, "This matter is not simple, Your Honor, and before any distribution is discussed, the court needs to see what was recorded yesterday." My sister's lawyer scoffed softly. "Recorded? This is probate, not—" My attorney didn't look at him. She reached into my damp folder and slid out a single document inside a clear sleeve, then walked it to the clerk. The clerk took it with both hands like it mattered. He glanced at the header, then at the stamp near the bottom. His eyebrows rose slightly and he set it in front of the judge. The judge read the top line, then the recording stamp. Not a photocopy, not my sister said. A certified copy, the kind with a raised seal you can feel under your thumb. And he didn't speak right away. He read again, slower this time. My sister's smile disappeared completely. She sat up straighter, eyes fixed on that page like she wanted to burn it back into the folder. The judge looked up. "This is a deed." My sister's lawyer stood again, too fast. "Your Honor, that's unrelated." My attorney's voice stayed steady. It's the estate's primary asset, and it was transferred out of the estate by a document that was recorded before this hearing. It is directly related." My father's face tightened. My mother finally looked at me, and her eyes didn't say shock. They said annoyance, like I'd ruined the plan's timing. The judge held the page up slightly and asked the clerk, "Is this certified?" "Yes, Your Honor," the clerk said. "It bears the county recorder's certification." The judge set it down and stared at my sister. "Ms. Pierce," he said, and he meant my sister this time, "did you cause this document to be recorded?" My sister blinked hard, then forced a smile. My lawyer handled paperwork. It's all proper." Her lawyer swallowed and said, "Your Honor, we can explain." The judge lifted one hand. Then he looked at my damp folder again, at the way it had been clutched through rain, and his eyes narrowed like he understood exactly why I'd walked in soaked. Because I hadn't come to argue feelings. I'd come to stop a theft that was already in motion. He leaned toward the mic, voice suddenly very controlled. "Clerk," he said, "pull the recording details and the notary information associated with this filing. Right now." The clerk's fingers flew over the keyboard, and at that moment the courtroom door behind us opened. A man stepped in wearing a suit that looked like it had never seen a courtroom bench, a badge clipped at his belt, a thin file in his hand. He didn't look around like a lost visitor. He walked straight to the clerk, handed over the file, and said something quietly that made the judge's face go still again. The man in the suit didn't take a seat in the gallery. He walked straight to the clerk, handed over the thin file, and showed his badge just long enough to make the bailiff stop moving. Then he waited, hands empty, posture still, like he'd done this in a dozen quiet courtrooms before. My sister's lawyer leaned toward her and whispered fast. My sister's face tightened, but she kept her chin lifted like confidence was armor. And the judge glanced down at the file, then up at the man. "Identify yourself," the judge said. "Investigator Mark Halpern," the man replied. "County District Attorney, Financial Crimes." The room changed without anyone raising their voice. My sister's lawyer started to stand, but the judge held up one hand again. "Why are you here, investigator?" Halpern looked at the clerk. "Your clerk requested verification on a deed recorded yesterday, tied to an active probate matter. I'm here because your request hit an existing flag." My father shifted in his seat behind my sister, suddenly interested in the ceiling. My mother's lips pressed into a thin line. The judge's tone stayed flat. An existing flag. Halpern opened the file and slid one sheet onto the clerk's desk. "This is a recorder fraud alert. The notary on that deed has been under review." The clerk took it carefully and placed it in front of the judge. I couldn't see every line from where I sat, but I saw what mattered: a county letterhead, a reference number, and a date stamp. Halpern added, "And I have the commission status." He pulled out a second page, simple, official, boring in the way that ends arguments, and handed it over. The judge's eyes moved left to right. Then he looked up, slow, and asked the question that wasn't dramatic at all. "Counsel," he said, "did your client file a deed notarized by someone whose commission is not active?" My sister's lawyer's face went a shade lighter. "That's," he began, then stopped, recalibrated. "Your Honor, we relied on the notary's representation. And if there's an administrative issue—" "It's not an administrative issue if the commission is expired," the judge cut in, still controlled. "It means the notarization may be invalid." My sister's smile tried to come back. It failed. She leaned toward her lawyer, whispering, "Fix it." Halpern spoke again, calm. "There's more." The judge's gaze didn't leave him. "Go on." Halpern opened the folder and produced a third page. This one looked like a standard request form, the kind nobody in the public understands until it hurts them. "Notary journal request," he said. "We asked for the journal entry connected to this signing. The response was incomplete." My sister's lawyer's pen slipped slightly in his hand. He caught it before it hit the table, but the movement was enough. The judge noticed. "What does incomplete mean?" the judge asked. Halpern's voice stayed professional. "It means there's no matching entry for the date and time listed on the deed, or the details don't align." My sister sat very still now. Not smug still, careful still. The judge turned to the clerk. "Read the recording stamp aloud." The clerk did, voice steady. The county, the date, the time, and the recording number. Then the judge looked at my sister. "Ms. Pierce," he said, and again he meant her. "Where were you when this deed was signed?" My sister blinked twice. "At my mother's house." The judge didn't react. "What time?" She hesitated, just long enough. "In the afternoon." The judge's expression didn't change, but his patience thinned. "Afternoon is not a time." "What time?" My sister's lawyer jumped in quickly. "Your Honor, she's under stress." "No," the judge said, still quiet. She's under oath." My sister swallowed. "Around 3. Halpern flipped a page in his file without looking up. The deed lists the notarization time as 11:16 a.m. My sister's head snapped toward him. "That's not—" The judge's voice hardened slightly, not louder, just sharper. "Answer the question you were asked." My sister's cheeks flushed. "I don't remember the exact time." I didn't move. I didn't look at my parents. I just kept my hands folded on the table, because this was the part they always hated: specificity. The judge turned to my sister's attorney. "Who prepared this deed?" "Your Honor, my office assisted with paperwork at the family's request." "At whose request?" the judge asked. "My client's," the attorney said, and then tried to smooth it. With the understanding the decedent intended to correct an unfair distribution." The judge leaned back slightly. "So you're telling this court that while a probate matter is pending, your client recorded a deed transferring the estate's primary asset out of the estate." My sister lifted her chin. "Grandma wanted it that way." I watched her say it like she believed repeating it would make it real. The judge looked down at the certified copy again, then at Halpern. "Investigator, what are you asking for today?" Halpern's answer was clean and terrifying in its simplicity. "Preservation order," he said. "Devices, emails, any drafts, any text communications tied to the deed and notary coordination. And I'm requesting this court place a hold on any further transfer or encumbrance of the property while we verify authenticity." My sister's lawyer stood fully now. "Your Honor, this is turning into a criminal matter. That's outside." The judge cut him off with a small shake of his head. "No, this is still my probate matter, and I am not going to allow the estate to be gutted while we pretend it's simple." He looked at the clerk. "Issue a temporary stay on distribution and an order maintaining the current status of the property." He looked at my sister. "No sale, no loan, no transfer, no new filings, not until this court says so." My sister's lips parted. And the judge added, "You will provide the notary's full information and any communications your side has with her by end of day. If anything is deleted, why, I will assume it was deleted for a reason." My father shifted behind her, suddenly uncomfortable with the way assumptions work when they're written down. My mother's eyes darted to my sister's lawyer, like she wanted him to fix time itself. Then the judge looked at me again, briefly, and his voice softened just enough to sound human. "Ms. Pierce," he said, "I recognize you. I haven't forgotten the way you handled records when you worked in this building." My sister's head snapped toward me, shocked, because she didn't know that part. She didn't know I'd spent 2 years sitting 3 doors down from this courtroom as a clerk, watching people try to win by acting loud. They never beat paper. The judge turned back to Halpern. "Investigator, when can you confirm whether this deed is authentic?" Halpern didn't hesitate. "We can start with devices today, and will verify the notary trail immediately." The judge nodded once, then looked at my sister's lawyer. "Counsel," he said, "if I find this filing was fraudulent, you understand I will refer it formally." My sister's lawyer swallowed. "Yes, Your Honor." My sister's voice came out tight. "So you're just going to believe her?" The judge looked at her, unblinking. "I'm going to believe what you can prove." Then the clerk's printer behind the bench whirred to life, spitting out a single page. The clerk took it, scanned it quickly, and his face changed. He handed it to the judge without a word. The judge read one line, then looked up at my sister's lawyer, and his tone turned dangerously calm. "This notary's commission wasn't just expired," he said. "It was suspended." My sister's lawyer went pale, and for a moment nobody spoke. Not because we were stunned, because the word suspended doesn't leave room for spin. My sister's attorney stayed standing, but his shoulders dropped half an inch, like his body knew what his mouth was still trying to deny. "Your Honor," he began, "a notary commission issue doesn't automatically—" "It's not an issue, counsel," the judge said, voice level. "It's a status, and it matters." My sister turned her head toward her lawyer, eyes sharp. "Fix it." He didn't look at her. He looked at the bench, and for the first time his confidence sounded like effort. "We can withdraw the deed and refile properly." "No," the judge cut in. "You don't withdraw a recorded deed like it's a typo. You unwind it through lawful process." The judge's gaze shifted to Investigator Halpern. Do you have the notary's name and commission number?" Halpern nodded and slid another page forward. "Yes, Your Honor, and I also have her response to our journal request." That got my sister's attention fast. Her eyes flicked to the page like she could edit it with her stare. Halpern handed the sheet to the clerk. The clerk took it, glanced once, and his mouth tightened the way people's mouths tighten when a page is worse than they expected. He placed it in front of the judge. The judge read silently for a long beat. Then he lifted his eyes slow and looked directly at my sister. "Ms. Pierce," he said, "according to this journal entry, the signer was not your grandmother." My sister blinked. "What?" Halpern's voice stayed calm. "The notary provided a scan of her journal page, and the name written for the signer is your name." My sister made a small, ugly sound. "That's a lie." The judge didn't react to the volume. He tapped the paper once with his finger. "The journal lists Kendall Pierce as the person who appeared," he said, "and it lists the ID presented." Kendall, my sister, stiffened like someone had pulled a wire through her spine. Her lawyer's face drained so quickly it looked like the blood just left. "That can't be right," Kendall said too fast. I wasn't." The judge's eyes didn't soften. "Then you're telling me the notary forged a journal entry?" Kendall hesitated, and in that tiny pause I could almost hear her picking which lie would cost less. Her attorney jumped in, voice tight. "Your Honor, the notary could have made a clerical error. These journals are—" "Counsel," the judge said. "Stop calling everything a clerical error." He turned to Halpern. "What does the journal say about the capacity? Did she sign as herself, or did she claim to sign for someone else?" Halpern flipped one page in his file. The notary wrote, "Signer stated she was authorized. There is a note that she mentioned a power of attorney." Kendall's lawyer swallowed hard. The judge looked at Kendall again. "Do you have a power of attorney for your grandmother?" Kendall's eyes darted to my mother in the gallery. My mother's face was stiff and unreadable, like she'd been told not to speak. Kendall started, then tried to regain altitude. "Grandma wanted me to handle things." "That wasn't my question," the judge said. Kendall's voice came out smaller. "No." The judge leaned back slightly, like he was settling into the part of his job that people don't enjoy watching. "All right," he said. So we have a deed recorded yesterday, notarized by someone whose commission was suspended, with a journal entry listing the signer as the petitioner, and a claim of authority that has not been produced." He looked down at the certified copy again. "And this deed attempts to move the estate's primary asset out of the estate." The courtroom stayed silent, but it wasn't the stunned kind anymore. It was the listening kind. The judge turned to the clerk. "Print the will's signature page from the docket, the filed copy. I want it on my desk." The clerk's fingers moved fast. A printer whirred. Paper slid out. The clerk carried it over and placed it beside the deed. 2 signatures. One from my grandmother's will. Steady, familiar, filed and stamped. One on the deed. Heavier, slanted differently, like someone had tried to imitate a hand they didn't live in. The judge didn't need a magnifying glass to see it. Kendall's attorney made a small, involuntary sound under his breath, like a man watching a door close from the wrong side. The judge looked up. "Counsel," he said, "do you still want to tell me this is simple?" My sister's lawyer didn't answer. Kendall tried to, though. She's twisting it. She always does this." The judge didn't acknowledge the family insult. He looked at Halpern. "Investigator, what do you need from this court today?" Halpern's response was short. A preservation order, no deletions, no device wipes, and an immediate hold on the property record so no lender or buyer can rely on this deed while we verify. My attorney stood and spoke for the first time in a few minutes, voice steady. "Your Honor, we're also requesting an emergency notice be sent to the county recorder today with your signature. If this deed stays live in the system, she can try to leverage it." Kendall snapped. "Leverage it how?" My attorney didn't look at her. Loans, lines of credit, a rushed sale. All it takes is one person moving fast and a title clerk who assumes recorded means valid. The judge nodded once, then turned to the clerk. "Draft the order. Put status quo in plain language. No transfer, no encumbrance, no new filings. Immediate notice to the recorder." He looked at Kendall's attorney. "Your client will not contact that notary." "Well, you will not contact that notary. If I learn anyone attempted to influence or coach a witness, I will treat it accordingly." Kendall's attorney opened his mouth, closed it. "Yes, Your Honor." The judge picked up his pen, paused, and looked straight at Kendall. "Ms. Pierce," he said, "you're under oath. I'm going to ask you one more time. Did you appear before that notary yesterday?" Kendall's throat bobbed as she swallowed. "No," she said. Halpern didn't argue. He simply reached into his file and set one more page on the clerk's desk. It was a confirmation email, plain formatting, official timestamp, the kind of thing people ignore until it ruins them. Halpern spoke quietly. "This is the mobile notary appointment confirmation. It was booked from an email address associated with counsel's office. Nigh it lists the signing location." Kendall's attorney's head snapped toward the page like he'd been struck. The judge read the location line, then lifted his eyes to Kendall's lawyer. "Counsel," he said, dangerously calm, "why does a notary appointment booked by your office list the signing location as a shipping store 2 blocks from your building?" Kendall's lawyer went completely still, and behind me, I heard my father's chair scrape the floor, like he'd just realized sitting quietly wouldn't protect him from what was being written down. "Counsel," the judge said, his voice steady, "answer the question." My sister's attorney looked like he wanted to pretend he hadn't heard it. He cleared his throat anyway. "Your Honor, the shipping store is a neutral location used for signings," he said. "It's common. It doesn't prove—" "It proves you knew where the signing was scheduled," the judge replied, cutting cleanly through it. "And it proves this was not some surprise document that appeared out of thin air." Behind me, my father shifted again, and the scrape of his chair sounded louder than it should have. The bailiff glanced toward him, not a warning, a note. Investigator Halpern didn't take the bait of an argument. He just opened his file and slid one more page forward, like he was adding weight to a scale. "Your Honor," he said, We requested preservation from the shipping store because it's listed as the signing location. They produced a transaction record tied to the notary appointment time. The clerk took the page and placed it on the judge's desk. The judge read it once. Then again, slower. Kendall's mouth tightened, and her lawyer's eyes tracked the page like he wanted to snatch it back. The judge looked up. This shows a notary fee paid at 11:14 a.m. at that location. Halpern nodded. Yes, and it was paid with a card in Ms. Kendall Pierce's name. Kendall's head snapped toward him. That's not true. The judge didn't look at her yet. He looked at her lawyer. Counsel, he said, are you still going to stand there and tell me you don't know what happened yesterday morning? Her lawyer's face went stiff. Your Honor, I need a moment to speak with my client. No, the judge said, calm and sharp. You had time for moments when you recorded a deed the day before a hearing. Then he looked at Kendall. Ms. Pierce, he said, you're under oath. I'm going to ask you again. Did you appear for that signing? Kendall blinked hard, like she could force the room to blur. No, she said. Halpern didn't react. He flipped to the next page, a simple printed log with header lines and timestamps. Then you'll want to explain this, Halpern said. The notary's scheduling app produced an activity log. It shows the appointment was confirmed from a phone number saved as Kendall. Kendall's lawyer swallowed so visibly it looked painful. My mother leaned forward in the gallery for the first time all morning. My father stared at the floor like he'd found something fascinating there. The judge raised a hand to stop the noise that was trying to start. Enough, he said. Clerk, print the docket activity report for this case. I want a clean timeline. The clerk typed fast. The printer whirred. Another page slid out, plain, official, and impossible to charm. The clerk placed it in front of the judge. The judge read silently for a moment, then pointed with his pen. This petition was filed electronically, he said, from an IP address tied to counsel's office network. Kendall's lawyer's eyes widened. Your Honor, filings are done through our system. That's normal. The judge nodded once. Filing through your system is normal. Filing a petition that claims manipulation and incapacity while simultaneously recording a deed to remove the house from the estate is not. Kendall's cheeks flushed. She's making it sound... I'm making it sound like what the paper says, the judge replied, and his tone stayed controlled. You brought this court a story. She brought a certified record. My attorney stood, not for drama, just to place one more thing into the lane of facts. Your Honor, she said. So we're asking for immediate recorder notification, a freeze on distribution, and a directive requiring the petitioner to produce any alleged power of attorney, originals, drafts, and communications tied to the deed. Today. Kendall's lawyer tried again. Your Honor, this is a probate courtroom, not it's my courtroom, the judge said flatly, and I will not allow a pending estate to be stripped while we argue semantics. He leaned toward the microphone, and his words suddenly had that clipped cadence clerks recognize, the one that turns into orders. Clerk, he said, prepare an emergency order maintaining status quo of the estate assets. Include a directive to the county recorder. Flag the property record and attach this order to the recording number. The clerk nodded and began typing. The judge turned to Halpern. Investigator, and you will receive a certified copy of today's order for your file. Halpern nodded once. Thank you, Your Honor. Then the judge looked at Kendall's attorney. Counsel, he said, I'm ordering your side to preserve all communications related to this deed and notary coordination. No deletions, no device wipes, no lost phones. If evidence disappears, I will treat that as intentional. Kendall's lawyer's voice came out tight. Understood, Your Honor. Kendall's hands curled into fists on the table. This is unfair. The judge didn't flinch. What's unfair is using this court as a stage while you move assets in the back hallway. My father shifted again as if to stand. The bailiff took one step toward the aisle, and my father stopped moving. The judge noticed anyway. He looked past Kendall to the gallery. "Sir," he said, and addressing my father without raising his voice, "sit down. You are not a party at council table. Do not interfere." My father's face tightened, but he sat. I felt the tiniest tremor in my hands under the table. Not fear exactly, more like the delayed realization that they'd expected to steamroll me the way they always did. They hadn't planned for the court to ask for specifics. They hadn't planned for a recorder stamp. They definitely hadn't planned for a financial crimes investigator to already have a file. The clerk finished typing and carried a draft order to the judge. He scanned it, made a small correction with his pen, then looked up at the room. "Here's what we're going to do," he said. "I am freezing distribution of this estate immediately. I am placing a hold on any transfer or encumbrance of the property tied to the recording number in front of me. I am ordering preservation of all relevant communications and setting an evidentiary hearing within 10 business days. And if the petitioner cannot produce lawful authority for that deed, this court will unwind it, and I will refer the conduct for appropriate action." Kendall's face drained so fast her smirk looked like something that belonged to another person. Her lawyer stared at the order like it was a trap he'd walked into with his eyes open, and when the judge lifted his pen to sign, the bailiff quietly moved closer to Kendall's table, holding a fresh stack of papers like the next step was already waiting. The judge signed the emergency order right there in front of everyone, or with the same calm he'd used to read the recording stamp. The clerk stamped it, made copies, and the bailiff walked one set straight to Kendall's table, like it was a bill coming due. Kendall didn't touch the papers. Her lawyer did, carefully, like the ink might transfer guilt. "Distribution is frozen," the judge said, looking over his glasses. "The property is on hold. No new filings, no loans, no sales. If anyone tries, the recorder will attach my order to the record. Understood?" "Yes, Your Honor," my attorney said. Kendall's lawyer cleared his throat. "Understood, Your Honor." Kendall's mouth tightened. "This is unbelievable." The judge didn't argue with her feelings. He just looked down at his notes and said, "We'll be back in 10 business days for an evidentiary hearing. Bring originals. Bring authority. Bring proof." When we stepped out into the hallway, my coat was still damp at the cuffs, but my hands felt steady for the first time in weeks. Kendall caught up to me near the elevators. Her voice was low, urgent, meant to sound like family. "You really want to do this in public?" I didn't stop walking. "You recorded a deed the day before a hearing." She hissed. "It was Grandma's house. It should have been split." "If you believed that," I said, "you would have waited for the court." Her lawyer touched her elbow, guiding her away like he suddenly didn't trust what she'd say next. My parents didn't come near me. My father stared past me like I'd turned into someone he didn't recognize. My mother's eyes were hard, less grief than irritation, like I'd ruined a plan they'd rehearsed over dinner. 10 business days later, and the courtroom felt different before the clerk even called the case. No smirks, no laughter, no whispering, just papers. Kendall showed up with a new posture, stiffer, quieter, like she'd been told to stop performing. Her lawyer looked like he hadn't slept. The judge opened the hearing without drama. "This is not a morality play," he said. "This is a record. Counsel, proceed." My attorney stood and handed the clerk 3 exhibits, each one simple enough to explain in one sentence. First, the county recorder's certification and the emergency hold attached to the property record, proof that the deed couldn't be used as leverage anymore. Second, the notary commission status showing suspension as of months earlier. Third, the notary journal response, where the signer's name was listed as Kendall, not my grandmother. Kendall's lawyer tried to object twice. The judge overruled him twice, both times with the same reasoning. "It goes to authenticity. Sit down." Then Investigator Halpern was called briefly, not for theatrics, just for foundation. He testified to one thing that mattered most. The fraud alert wasn't triggered by my complaint. It was triggered by the notary's status and the recording pattern. The system flagged it before anyone could explain it away. The judge's attention stayed on Kendall. "Ms. Kendall Pierce," he said, "you filed this petition alleging manipulation and incapacity. Yet you also attempted to transfer the primary asset out of the estate the day before this hearing. Explain that." Kendall's voice came out tight. "I was protecting the house." "From what?" the judge asked. She hesitated. "From her." The judge didn't react emotionally. He just nodded slightly as if she'd said the quiet part out loud. My attorney asked permission to introduce one more piece of evidence. The judge granted it. A still image. Not grainy gotcha footage. Just a clean screenshot from the shipping store's security camera. Time stamped to the minute. A woman in a tailored coat at the counter, card in hand, signing a clipboard. The notary's stamp kit on the counter beside her. Kendall. Her lawyer's face drained so fast it looked painful. Kendall stared at the image, then at the judge, and tried to talk her way out like she always had. That could be anyone. The judge didn't raise his voice. He looked down at the receipt log that matched the timestamp, then back up. "It's paid with your card," he said. "And the journal lists your name." Kendall's lawyer stood, voice strained. "Your Honor, even if my client appeared for a signing, that does not—" "It does," the judge said, cutting through him with one sentence, "because she had no legal authority to sign for the owner, and the notary had no legal authority to notarize." He leaned forward. "This deed is void," he said. Kendall's shoulders sagged like her body finally understood what her mouth had refused to accept. The judge continued, tone controlled and specific, exactly the kind of tone my family couldn't manipulate. "I am ordering immediate corrective action with the county recorder to unwind the recording and restore the chain of title to the estate. I am awarding attorney's fees to the respondent. I am referring the notary matter and the circumstances of this attempted transfer to the appropriate authorities. And," he looked directly at Kendall, "I am placing you under a court order not to contact vendors, clerks, or any third party related to this estate. Any violation will be treated as contempt." Kendall's lawyer leaned toward her and whispered something that made her eyes flash with panic. She looked at me then, finally, like she wanted me to soften it. I didn't, because soft is what she counted on. 2 weeks later, I stood at the county recorder's counter with a certified copy of the judge's signed order in my hands. No speeches, no cinematic music, just a clerk who scanned the document, stamped it, and said, "All right, this will be attached to the record and the voided recording will be noted. One stamp, one record correction." And that was it. The property wasn't taken back with a fight. It was restored with paperwork. My attorney called me that afternoon and told me the fee award had been entered as a judgment against Kendall. The amount wasn't symbolic. It hurt, and it was enforceable. Kendall tried to tell people she'd been set up. She tried to blame her lawyer. She tried to blame me for turning it into a thing. But the court didn't run on stories anymore. It ran on timestamps, seals, and the kind of signatures you can't fake when someone actually checks. My parents went quiet after that, not because they felt sorry, because they finally met a door they couldn't push open. Kendall didn't get the house. She didn't get the leverage. She didn't even get the satisfaction of watching me scramble. When what she got was a record that follows her, every time she tries to file something, every time she tries to claim she's the victim, every time someone says, "Show me." A month later, I replaced the locks at the house. New hardware, new codes, no old access lingering in an app I forgot to check. I stood in the doorway and let myself feel one honest sentence without dressing it up. I didn't want revenge. I just wanted it to stop. If your sibling dragged you into court and tried to move assets behind the judge's back, would you fight to keep the peace, or would you let the record do what it was built to do? Drop your answer in the comments. And if you want more stories where evidence beats performance, hit like, subscribe, and I'll see you in the next one.